Mr. Riordan, good morning.
Good morning, Your Honors. Attorney Theodore Riordan on behalf of Mr. Upton. With me today is my partner, Deborah Riordan, and Mr. Upton's family is in the audience. Your Honor, this case presents the interesting question of the Commonwealth charged Christopher Manaloulis with murder one, and then used him as its prime witness in 2 murder trials against his co-defendants.
Doesn't it have to be an express promise as opposed to an implied expectation or an implied promise?
Oh, no, the law is very clear that it does not need to be expressed, that it can be implied, it can be something less than written down, as long as there is some kind of understanding that there's going to be some benefit, which I would suggest to you when he's testifying for the Commonwealth in 2 cases, when he's got a murder one charge pending against himself, there's some kind of a wink and a nod that if you perform, well, you're going to end out okay.
I think it's clearly erroneous because of the circumstantial evidence that surrounded it?
Yes, yes. But that's not my only argument about the newly discovered evidence. There's also the fact that when Chris pled guilty to manslaughter, he acknowledged that he had homicidal intent in this case. And that's very significant because when this case was tried, it was on the posture of Chris was a 17-year-old, malleable, impressionable kid.
Your point is that you can't reconcile the manslaughter plea with the trial testimony.
Yes, right. And the Commonwealth's entire case was based on this kid was innocent. He didn't do anything wrong. He had altruistic motives. He had never intended to harm anyone. But again, he made himself out to be innocent. No intent to harm in this case. But Mr. Upton's whole point in this trial was that Chris was a conniving prevaricator, that he's the one who committed this crime. And now his plea, admitting his homicidal intent, his manslaughter, it substantiates the defendant's position at trial in this case.